Hey guys, welcome to week 2 of this crazy thing we're doing. I wanted to do a lecture on Miranda, and I'm going to start with some background. And Miranda is just sort of our way to get talking about confessions and the sort of erosion of rights past Miranda. So want to start with a little bit of background on Miranda. Much of this is review for you guys, both from what we've talked about in the class and from your high school classes, but just to put it all out there. Obviously, the first backdrop was the civil rights movement and the role that law enforcement played in opposing it. So I'm sure you know about these incidents from high school, but just to reiterate them as the court would have encountered them at the time. One thing is that the practice of filming and showing the footage of events on the evening news was just then becoming standard practice. So, for example, when Police Chief Bull Connor turned fire hoses and dogs on thousands of elementary and high school students who were staging a walkout in Birmingham and arrested 1,200 of them, the youngest of whom was 8, we all saw that on television. So the horrifying pictures and stories, of children being beaten into paddy wagons was the top story around the country. So all of a sudden there's not only the civil rights movement, but there was also a awareness of it. And then meanwhile, a former prosecutor and judge, so former law enforcement, George Wallace, was sworn in as governor of Alabama, proclaiming segregation now, segregation tomorrow, segregation forever. And in 1964, so just a few years before Miranda, police in Philadelphia, Mississippi, worked with the KKK to arrest and murder 3 young men who were registering Black people to vote in Mississippi. And a lot of this was more or less legal, or at least the court had little recourse to stop it. So then there was the way that the Warren Court, which ran roughly from 1953 to 69, reacted to this. We've already talked about their activism some, but just to list some of those provisions together so you can kind of see it as one unit. They ruled that the 14th Amendment meant that the 4th, 5th, and 6th Amendments applied to everyone. They ended school racial segregation with Brown v. Board and a couple other cases. They ruled anti-miscegenation laws unconstitutional with Loving v. Virginia. They concluded that the Constitution does grant a right to privacy, even though it doesn't use the term privacy. So that's something that's been in the backdrop, but that happened with the Warren Court. It also gave extremely broad protections to the First Amendment and gave us that familiar phrase that short of shouting fire in a crowded theater, almost all speech is protected from the government. It also gave us protections for the criminal defendant, including Katz, which we talked about, Gideon also talked about, and then now Miranda. A little bit of interesting trivia, Miranda actually filed cert for himself and was denied. Then he caught the attention of the ACLU, who provided him counsel, and then cert was granted. So originally when the court heard Miranda, when they granted cert, they thought that it was going to be about the 6th Amendment right to counsel, not about the right to not incriminate yourself. This is because several things happened in quick succession leading up to Miranda. So as you know, in 1963, Gideon v. Wainwright established public defenders. And then 1 year later, Messiah v. United States found that once a suspect is formally charged, any confessions must be taken in the presence of a lawyer. In the same year, Escobedo, he was being interrogated and requested his lawyer. His lawyer was also present in the station house and asked to see him, so there was sort of mutual agreement, and he knew to ask for his counsel. But they did not give him counsel because he had not yet been charged. So the police continued to question him for 3 hours and got their confession. At this point, the court made a confusing ruling that essentially said that he should have been given counsel because once a criminal investigation has focused on a specific suspect, that is when the right to counsel begins, whether or not charges have been brought. But of course, that opens up the question, when does a general investigation become a focused one? So 2 years later, 150 requests for cert stemming from differing Escobedo interpretations had been sent to the Supreme Court. So when they granted cert to Miranda, they were most likely expecting to rule on this focusing question, which is why a lot of the oral arguments actually in Miranda centered on when this focusing takes place and when the right to counsel kicks in. So I'm just gonna show you a transcript from the oral arguments, but you can listen to all of this yourself if you want on Oyez. This one I think starts around minute 14, and the other one that I'm gonna show you starts around minute 25. So if you want to go and take a look at those, you can. It's kind of interesting to hear the oral arguments and see how rapid fire they are. It's not like one person makes statements and then the justices respond. The justices constantly interrupt and ask for clarification, and it gets pretty aggressive actually. So, okay, so Flynn is Miranda's counsel. Provided by the ACLU. When the process shifts from the investigation to one of accusation, and when the purpose is to elicit a confession from the defendant, then the adversary process comes into being. So he's trying to identify what this focusing is. Justice Stewart asked him, what do you think is the result of the adversary process coming into being? What happens next? And Flynn says, I think that the man at that time has the right to exercise if he knows, and under the present state of the law in Arizona, if he is rich enough and if he's educated enough to assert his Fifth Amendment right, and if he recognizes that he has a Fifth Amendment right to request counsel. I simply say that at that stage of the proceeding, under the fact and circumstances in Miranda of a man of limited education, of a man who certainly is mentally abnormal, who is certainly an indigent, meaning poor, that when that adversary process comes into being, that the police, at the very least, had an obligation to extend to this man not only his clear Fifth Amendment right, but to accord him the right of counsel. Justice Stewart asked, what would a lawyer advise him that his rights then were? And that he had a right not to incriminate himself, that he had the right not to make any statement, that he had a right to be free from further questioning by the police department, that he had the right at the ultimate time to be represented adequately by counsel in court, and that if he was too indigent and poor to employ counsel, that the state would furnish him counsel. So you can see there that's actually almost word for word the Miranda warnings. So they took those from Miranda's lawyer. And it established, so on this issue, the court decided, yes, the adversarial process does begin before trial and before charges. It starts at arrest. And that was the moment for the right to a lawyer. But part of Flynn's argument here, obviously, is that this right doesn't exist unless you know that it does, which obviously favors wealth and education. And he's pointing out that in this case with Miranda, he would not have known we can't expect him to have known his rights. And if you didn't know you had a right to counsel, then being interrogated was tantamount to compulsion. So this is sort of where the court and where Flynn went next, which was to say, Justice Stewart asked him, is there any claim in this case that he was compelled, that his confession was involuntary? And Flynn says, no. Justice Black asked, he didn't have a gun pointed at his head, does he? And he doesn't have to have a gun pointed at his head, does he? So that's like the standard for compulsion. And Justice White says, of course he does. So he was compelled to do it, wasn't he, according to your claim? And Flynn is trying to make an argument about compulsion. He says, not by gunpoint. He was called upon to surrender a right he didn't fully realize and appreciate that he had. And that constitutes compulsion. And Justice Black sort of helps him out a little bit here and said, wouldn't you add to that effect if the state had him in its control and custody? Would that not tend to show some sort of coercion and compulsion? Was he allowed to get away from there at will? Flynn says, no, Your Honor, he was in confinement and under arrest. Black asks, the state had moved against him by taking him in and to question him, did it not? Flynn says that is correct. So at this point, they're pivoting towards the Fifth Amendment when they're talking about compulsion. So part of the Fifth Amendment is that no one shall be compelled in any criminal case to be a witness against himself. So to address this issue of compulsion, the majority also decided that it was necessary to inform people of their rights so that they could make use of them. And furthermore, that they had to explicitly waive those rights for them to be considered waived. So Miranda, as you've probably gathered at this point, having read a bunch of Supreme Court cases, is a very unusual case for making a bright line rule for law enforcement. So instead of hoping for a kind of trickle-down effect from the exclusionary rule where, bad police conduct will be curtailed by the threat of having it excluded at trial, they went ahead and directly created police procedure. And this is kind of the height of criminal defendant protections, which have waned since then, as you'll see in Missouri v. Siebert and Oregon v. Elstad. So a couple questions to think about below. Do you think a bright line rule was a good choice here? Do you think that was the best way to inform people of their rights and make sure that they understood them? Do you think people are better informed about their rights now? To that end, take the little quiz I've linked below and see how well informed this class has made you. I'm curious, and we'll see what things we haven't covered. More broadly, why do you think this clause, this Fifth Amendment clause that they sort of ended up on, that you not be compelled to give evidence against yourself, exists? Because you can be compelled to give evidence against others through subpoena. So what is it about confessions that shouldn't be compelled within the structure of our legal system? Just to give you a closing story, after Miranda was granted these rights, he was still convicted and he was sentenced to an additional 20 years. After he was released, he was murdered during a card game. And his killer was caught by the police as he fled. And as they put him in the back of the cruiser, they got out a small card and read to him, "You have the right to remain silent," etc. So just a funny little story to end on. Hope you guys have a great week. Don't forget that Wednesday at 1:30 and 8 p.m. Eastern Time are my office hours. And then on Friday at 1:30 p.m. Eastern Time, I have a sort of open discussion. Last week was a little bit more of a lecture. This week it'll be mostly discussion because I really want to get talking about Miranda and about confessions more generally. All right, thanks guys.